Hear ye, hear ye. The following scene is a reenactment of Perry versus Schwarzenegger, the Prop 8 trial heard in the U.S. District Attorney. Dr. Nancy Cott, professor of the American History at Harvard University, expert witness for the plaintiffs on the history of marriage, is under direct examination by the plaintiff's lawyer, Theodore Lotres. The plaintiffs in this case are two loving same-sex couples who simply want to marry, just as any heterosexual couple in America has the right to do. Court is now in session.
Yeah, well, first of all, marriage, the ability to marry, to say I do, it is a basic civil right. It expresses the right of a person to have the liberty to be able to consent validly. And this can be seen very strikingly in American history through the fact that slaves, during the period, the long period that American states had slavery, slaves could not legally marry.
Why were slaves barred from marrying?
Because as unfree persons, they could not consent. They lacked the very basic liberty of person, control over their own actions that enabled them to say, I do, with the force that I do has to have, which is to say, I am accepting the state's terms for what a valid marriage is. The slave couldn't do that because the master had rights over the slave's ability to disport his person or to make any claim. The slave could not obligate himself in the way that a marriage partner does obligate himself or herself.
What happened when slaves were emancipated?
When slaves were emancipated, they flocked to get married, and this was not trivial to them by any means. They saw the ability to marry legally, to replace the informal unions in which they had formed families and had children, many of them, to replace those informal unions with legal, valid marriage in which the states in which they lived would presumably protect their vows to each other. In fact, one quote that historians have drawn out from the record, because many of these ex-slaves were illiterate, of course, but one quotation that is the title of an article a historian wrote, it was said by an ex-slave who has also been a Union soldier, and he declared, "The marriage covenant is the foundation of all our rights," meaning that it was the most everyday exhibit of the fact that he was a free person. He could say, I do, to his partner. And then in corollary with that, because of course the history of slavery is happily behind us, there are other ways in which this position of civil rights, of basic citizenship, is a feature of the ability to marry and to choose the partner you want to choose.
What would be an example of another one of those features?
Well, I want to use an example of that. That again doesn't have to do with the slave. It has to do with a black man, Dred Scott, who tried to say when he was in a non-slave holding state that he was a citizen, and in an infamous decision, the Supreme Court denied him that claim. And why this is relevant here is that Justice Taney spent about 3 paragraphs of that opinion remarking that the fact that Dred Scott, as a black man, could not marry a white woman. In other words, that there were marriage laws in the state where he was and many other states that prevented blacks from marrying whites, was a stigma that marked him as less than a full citizen. Because if he had a free choice, Taney wouldn't have mentioned it, but he remarked on it because to the extent to which this limitation on Dred's ability to marry was a piece of evidence that Justice Taney was remarking upon, in his opinion, to say this shows he could not be a full citizen.
Now, going back to the era of slavery, would slaves form something they would call marriage, or that the slave owners would call marriage, at least informally?
Yes.
And was that viewed by the state or by society as an important relationship?
Certainly, it was regarded as an important relationship within slave communities. There were only the relationships they had, these informal relationships, that they were totally treated with abandon by white society, broken up all the time, and no state authorities gave any protection or credence to these relationships whatsoever.
And, as a historical matter, to what do you attribute the desire to be formally married by the state upon emancipation?
Well, it was, as I suggested, because this was a common sense indication of freedom, of possessing basic civil rights, and because they assumed it would mean to them that white employers, because of course, the ex-slaves were still quite poor and employed by whites who were, well, at any rate, white employers, would often try to demand that families worked in certain ways, or that children worked, and so on. And so the emancipated, the freed men and women, assumed that only once they were legally married that they could make valid claims about their family rights.